Another Friday evening, another government announcement with regards to the private rented sector. The latest announcement is around civil proceedings or changes to possession claims in the courts. Now, this is not a legislation change under the Coronavirus Act, more additional things you now need to do for any possession claim that you currently have in court. So, as we know, the courts are currently closed. They are due to reopen again on the 24th of August, and these civil proceedings come into force on the 23rd of August. So that's good news in a way, that it looks like the courts will actually reopen at the end of August. The good news also is that these proceedings are not the full pre-action protocol that were mentioned in the Coronavirus Act and the subject of a previous video. So it's maybe not as onerous as we may be expecting. However, there are now additional hoops that you need to jump through in order to regain possession of your property. So the first thing to bear in mind is that if you issue a Section 21 or a Section 8 notice before the 3rd of August, so if you've already got one in trains currently in limbo, or you've issued one during lockdown, then this applies to you. What you need to do is you need to put in writing to the court and to the defendant your intention to carry on with your possession claim, and this is known as a reactivation notice. And you need to do this, otherwise your claim is going to be lost. Now, at the moment, there's no prescribed form or template that's been provided. Hopefully this will come, or more information to follow soon. But this is a key point in that you really do need to be talking to your solicitor or legal advisor to make sure that you get your reactivation notice submitted. Secondly, as a landlord, you need to document to the court any changes to the tenant's situation as a result of the coronavirus crisis. So, for example, are they deemed as vulnerable? Have they been, or are they shielding? Has their social security position changed? And you need to document this and let the court know so that they can take this into account at the hearing. And the third major change is that you also now need to document the full rental arrears before the hearing to present this to court. Previously, this would have been taken to court at the time of the hearing. This now needs to be provided in advance. The other main point to bear in mind is that previously, once a claim form was issued, you would then get a hearing usually within a period of up to 8 weeks. This 8-week period has been removed under these civil proceedings. This is to allow the courts to schedule cases as they see fit and to give them more flexibility to cope with what they're expecting to be a backlog once the courts reopen. So it could be that your hearing is more than 8 weeks after the claim form has been issued. So do bear in mind there may be extra delays in the process here. So all in all, that's a quick summary of the new civil proceedings. There is definitely more things to be aware of and more things to do, but at this stage the good news is it's not the full pre-action protocol, and it's also not implementing the 6-month notice period that's recently been announced in Wales.